President Tinubu's victory has been affirmed by the justices of the Supreme Court, who are the final arbiters in the presidential election petition matters. With this judgment, President Tinubu says he is inclined to do more for Nigerians as he can fully focus on governance. The seven-man panel of the Apex Court, led by Justice Iyan Okoro, in a unanimous judgment resolved the 7 issues for determination in the appeals filed by the presidential candidate of the People's Democratic Party, PDP, Atiku Abubakar, and his Labour Party counterpart, Peter Obi, in favor of President Tinubu. The legal battle started in March when Atiku Obi, the Allied People's Movement, and 2 others approached the Presidential Election Petitions Court to challenge the Independent National Electoral Commission, INEC's declaration of President Tinubu as the winner of the February 25th presidential poll. Now, the president has hailed the Apex Court's verdict, saying the court has done justice to all issues put up for consideration and urged all Nigerians to join hands with him to build the country. Well, joining us via Zoom from Paris is a senior advocate of Nigeria, Unle Adegoke. Good morning. Thank you for joining us.
Good morning. It's my pleasure to be here.
Now, let's get your perspective to the ruling of the justices on this matter. There's been divergent reaction to this issue, but let's get your perspective first of all.
Thank you very much.
Right.
The decision of the Supreme Court on the election petition appeals filed by Alhaji Atiku Abubakar and the former governor Peter Obi were decisions granted by the Supreme Court in full consideration of the law and in full appreciation of the facts presented by the parties. It is a judgment that actually upholds the sanctity of the law, that deepens democracy, that promotes the need to be conscious of the requirements of what election petition requires before approaching the court. It is a decision that I believe over time, more Nigerians will come to appreciate, more lawyers will come to celebrate on the basis of the fact that when you approach the tribunal challenging the declaration of a winner of an election, there are certain things you need to do. Where you fail to do them, it will be better for the court to throw out such a petition than to just glorify public sentiments or emotions without addressing what will actually promote the sanctity of the law and the genuineness of electoral justice. That is my appreciation of the decision of the Supreme Court in the 2 appeals.
I'm talking about the sentiments which a lot of legal counsels and also legal luminaries have spoken to, saying that emotions cannot influence the judgments that will be given by the courts. But still, some people are still holding on to the fact that whatever it's written in the Constitution as regards Section 299 of the 1999 Constitution as amended, talking about the FCT and the status, saying that it enjoys special status, despite the fact that a lot of people have tried to explain this, even the Supreme Court putting paid to this. Some are still holding on to this fact that the FCT, the 25% FCT, is still very, very important. What's your reaction to this?
I believe those who are promoting that jaundiced view are quite not doing justice to the interests of Nigerians. And it doesn't accord to sanity to say that 25% in Abuja is a prerequisite before a person could be declared winner of a presidential election. Let me put this question across to them. Assuming I won the election in the 36 states of the Federation, but I now lose the election in Federal Capital Territory, Abuja, by not securing 25% votes cast in Abuja. Does it mean that I cannot be declared winner? Does it mean that anybody who fails to secure 25% of the votes in Abuja would not be declared winner of such an election? Would it not be tantamount to saying that Abuja enjoys a status higher and above the status of other states of the Federation? and those are actually the federating units. This will not accord with reasoning if we are to subject it to critical appreciation of what the framers of the Constitution actually intended by putting that provision there. In the past, when Lagos was the Federal Capital Territory, did it enjoy such status in any election? Had we not conducted elections in Nigeria before Abuja became the Federal Capital Territory in about 1991? What exactly are the promoters of this jaundiced position trying to promote? Abuja is just like a state of the federation by the provision of the Constitution. It cannot enjoy a superior and better status than any other federating unit. Where somebody has secured the requirements of the Constitution in at least 24 states of the federation, and he has met the requirement of having the majority of the polls cast, that person must be declared winner of the election. By the time we now promote Abuja above other states of the federation, then what are we trying to achieve? That is the point that we try to make them to realize during the conduct of the trials at the Election Petition Tribunal, because I was involved on the side of the council, the legal team representing Asiwaju Bola Ahmed Tinubu and All Progressives Congress. We made this fact clear to them. There have been authorities earlier that have interpreted to Abuja not to be superior to a state of the federation. Yet the promoters of this position of Abuja enjoying a better status still kept on promoting it, still kept on, uttering this, incomprehensible position. And despite the fact that the Court of Appeal made a very thorough analysis of what actually is the position of Abuja within the conglomeration of states and the Federal Capital Territory forming Nigeria, still they went ahead. For instance, when you look at Abuja and maybe, let us say the smallest state, which is Bayelsa, you see that Abuja doesn't enjoy maybe a bigger territory or maybe a bigger representation at the National Assembly than a state like Bayelsa or any other state of the federation. So in what way are we now going? It's only during elections for the purpose of now computing who actually won election that we are now going to make Abuja to be superior to all the states of the federation. Come on, this doesn't accord with sense.
That's right.
So as duly done by the Supreme Court.
Sorry to jump in. For this reason, do you now think it's very expedient that this particular section of the Constitution be rewritten for clarity, so that those who want to, hold strongly or firmly to it will have it understood? Or do you feel there is need for it to be rewritten, or just to be left that way, and it's maybe because it's clear enough or not?
It is clear enough. It has been interpreted by the Court of Appeal as a presidential election petition tribunal. It has been interpreted by the Supreme Court. The final interpretation has been given by the highest court of the land. There is no need for it will amount to indolence and lack of sense of purpose on the part of the National Assembly to now say, oh, because some people agitated, because some people said this provision should be interpreted contrary to the position of the court, then they will go and amend it. No matter how much effort they make to make it clearer, it cannot supersede what the Supreme Court had interpreted. The purpose of the judiciary is to interpret the law. Having interpreted that particular provision of the Constitution, then it is now clear beyond any disputation. Where anybody comes back to or goes to any court to interpret that provision contrary to the position already stated by the Supreme Court, that person is calling for award of very heavy costs against himself, because it ought to be punishable. Where a party is agitating an issue that has been determined and still urging the court to interpret it otherwise, will the High Court, Federal High Court or State High Court, now interpret that provision contrary to what the Supreme Court has stated? Can any court of appeal, any division of the Court of Appeal in Nigeria today interpret that provision contrary to what the Supreme Court has stated? Now, that provision has been critically examined by their lordships of the Supreme Court, and they have given their interpretation to it. That is the final. It will be absurd, even for the legislature, to now say for you to be clearer. No matter how much language they use, it is still subject to interpretation by the court. And the implication is that whatever language, no matter how much they even try to make it clearer, or whatever effort they want to put in to make it more lucid according to their own wisdom, it cannot supersede the supreme wisdom of the court. And that is why I would say that the National Assembly should not waste our precious financial allocations given to them, should not waste the precious time, legislative time, to be considering such an issue. For those who don't want to take it, that is the correct interpretation of the law, there is nothing anybody can do to help them. They are entitled to their opinion, but their opinion doesn't count when it comes to the interpretation of the Constitution, no matter the status of such a person. Let him even be a superior, most supreme senior advocate in Nigeria. It cannot substitute or supersede the decision already given by the Supreme Court on this issue.
All right, another matter, that has also been generating reactions is the matter of the fact that the Supreme Court said it cannot admit the fresh evidence in terms of receiving that evidence put forward by the PDP presidential candidate with regards to the Chicago State University certificate brought forward by him to the courts. And that is raising questions as to why the Supreme Court did not receive that evidence, so to speak. If you could just clarify that for our viewers to better understand.
Right. The lawyers who sponsored that issue of admitting fresh evidence, I want to, with maximum respect to all of them, because many of them are my seniors at the inner bar, both at the outer bar and the inner bar. And they are people that I so much respect. They are leaders of the bar, excellent leaders of the bar in their own right. They are not only my superiors, many of them were my tutors when it comes to the issue of law. However, in this particular instance, it is the same law that all of us read. And no matter the fact that, okay, we belong to the different divides in this particular election petition, I want it to be clearly stated that they were not, I'm sorry to say this, they were not being honest to Nigerians on this particular issue. All of us know the requirements of the law when it comes to admitting fresh evidence at the appellate level. One, which is most important, is that the fact that you are agitating should be admitted with respect to a fresh evidence must have been pleaded in your petition, must have been pleaded in your statement of claim, were it to be an ordinary civil matter. Pleading is the soul of litigation. That particular statement of the law, as I've put it across, is well known and established, and it is a point that none of the senior advocates or any lawyer involved in these two election appeals can controvert. What we say that pleading is the soul of litigation is a fundamental principle. What you did not plead, a case you did not make at the trial, what you did not allege at the trial, you cannot give evidence of it even at the trial level, not to now talk of giving evidence of it on appeal. In the election petition filed by His Excellency Alhaji Atiku Abubakar, paragraph 146 of that petition is the only paragraph, is the only statement where it was tacitly stated that Asiwaju Bola Ahmed Tinubu was not qualified to contest that particular election as at the time of the election. And why? That paragraph stated that because it did not meet the constitutional threshold. Now, when we responded to that particular fact, we said Asiwaju Bola Ahmed Tinubu was qualified to contest the election at the time of the election because he met the constitutional threshold. That is the end of that pleading. In law, that is the end of that pleading. Were it to be that they wanted to make a case that he did not go to Chicago State University, or that he did not graduate from Chicago State University, or that the certificate that he brought forward that he submitted was not obtained from Chicago State University, they were supposed to have stated all these facts expressly. They must be documented. You don't plead piecemeal in litigation. You don't advance your cause half-heartedly, haphazardly in litigation. You have to front-load your facts. The other party will know what you are alleging. For instance, if I say your Zubakun did not go to university, or I mean, is not constitutionally qualified to contest an election. The next question somebody will ask is, why did you say so? Is it that he was not he's not a Nigerian citizen, or that he did not, it's not up to maybe 45 years of age as may be required by the Constitution, or that he was not sponsored by a political, somebody who want to know. No, you don't plead by allowing or putting it across to your opponent to now be asking questions. Why are you saying I'm not qualified? No, that is not the procedure. They all know that the procedure is that you must plead the facts expressly. So the other party will know what exactly you are alleging and will be able to controvert you. Where you plead that way and you want the court to take an evidence on an unpleaded fact, the law is that evidence adduced in support of an unpleaded fact goes to no issue. It must be disregarded. There are 1 million authorities, decisions of courts on that issue. That is one. Two is that evidence that you want to adduce on appeal, that particular evidence must be one that with reasonable diligence couldn't have been obtained, couldn't have been discovered by you at the trial court. Let me ask you this question. Can they say in all honesty that evidence they wanted to adduce at the Supreme Court couldn't have been discovered with due diligence, with reasonable diligence? No, not at all. The Chicago State University was not established last month. Chicago State University had always been in existence. The fact that Asiwaju Bola Ahmed Tinubu attended or did not attend that particular university had been a point raised way back in 1999, 2000, thereabout. And evidence was produced showing that this man couldn't have had all these A scores in this university if he did not attend this university. If you are saying that he forged the certificate, where did you say it in your petition that this man forged this certificate? Now, forgery is a criminal allegation. You don't adduce evidence of forgery without pleading it. I must have accused you of something so that you will be able to defend it before I can say I want to prove that particular allegation. Where there is no allegation, there cannot be a proof, for God's sake. Now, now insisting that this particular line of evidence must be admitted by the Supreme Court, are they saying that the Supreme Court should jettison all established principles of law that have been consecrated in many decisions of the court because they wanted to appease some section, some mob that have been mobilized by a particular politician or a number of politicians to see things contrary to what is in accordance with reason? Are they saying that we must repudiate the position of the law, not only established by the Nigerian Constitution or the cases decided by all courts in Nigeria? These are principles that we took from the English common law. And once we are talking about English common law, we are not talking about Nigeria or a few countries in Africa. We are talking about the Commonwealth, many countries all over the world. So it is the same in the United States, that facts that you are going to adduce evidence on must be pleaded. It is the same thing in the United Kingdom. Go to Australia. Yes, we are citing Australian cases. We are citing Ghanaian cases in the Nigerian court, interpreting this. Even Indian cases, foreign cases are equally recognized by our courts, though they are not binding. Where they are consistent with the interpretation of our law, will be given recognition by our courts.
Well, maybe that's the reason why Senior Advocate of Nigeria, Robert Clark, said that the lawyers, the counsels didn't do their due diligence, just like you've also punctuated here. The Supreme Court also described some of the PDP's deposition as very shocking, as well as that of the Labour Party, where it said that the legal counsels went to the Supreme Court on the issues. The Supreme Court, the issue of double nomination, which was being described as judicial rascality, saying that it amounts to the party asking the Supreme Court to adjudicate on a matter that it has clearly decided upon, and that's not really tidy enough. So that's why some said, well, it would have been better for the Supreme Court to have fined these parties, or probably these councils, these legal councils for those parties. Where do you stand on this?
Yes, one thing is this. It is not the making of a lawyer. It is not the fault of a lawyer to be briefed on a bad case. Yes, all lawyers, we have what we call cab rank rule in law. And the meaning of cab rank rule is that just like the taxi cabs, you know, when you go to a taxi park and you see taxis, you know, already lined up one after another, the next one is the one that you must enter. That is why they call it cab rank rule, according to how they rank. Now, that is the rule that applies to lawyers taking cases from litigants, from their clients. So when clients come and they brief us, yes, we are supposed to take the case or cases as the case may be. Now, it is now incumbent on us. It is part of our professional ethics to ensure that we explain to such clients very well when they have bad cases. Yes, you may go to court trying to see whether you can make a good case out of a bad one. There is nothing bad about that. But when you discover that, no, this case is bad, don't try now to make the judiciary to be the culprit. Don't ram it down the truth of the populace that what you are saying is correct, when actually you know that what you are promoting is not consistent with what the law has stated. Now, when you look at the two petitions, I don't want to use the language that they were badly drafted. I would say that they were empty petitions because the cases themselves were empty from the beginning. These were petitions that were presented simply because they wanted to challenge the victory of the person declared winner of that particular election, not because they actually had a genuine belief that they won that particular election. Alhaji Atiku Abubakar, with all sense of responsibility, couldn't have honestly, legitimately believed that he won that election. His Excellency, former Governor Peter Obi, couldn't have honestly believed that he actually won that election. The only Obi that was very known and that is still very known in most northern parts of the Federation is Michael Obi, not Gregory Peter Obi. So now, and we cannot substitute one for the other. In this particular case, the petitions were not, the cases were bad. A good petition is not likely to have been made out of them. And when you look at the petitions, it equally means that the petitions themselves were bad, because the pleadings, for instance, that of His Excellency former Governor Peter Obi, did not contain anything quite reasonable. It wasn't a petition that was challenging the results of the elections from the polling units. Elections are like pyramids. They start from the base, the lowest level, which is the polling units. They now build up gradually, yes, to the ward level, to the local government level, to the federal constituency level, to the senatorial district level, then to the state level, then now to the federal, the national level. That is how election petitions are considered. You must adduce, you must bring results at the polling units that actually show that you won this particular election. In fact, you may not bring any other thing. The court will now be compelled to now look at the results from the various polling units and say, if you had all these polling units together, Mr. A will be the winner, rather than Mr. C that was declared by INEC. And that is the only situation when the court will now nullify the results as declared by INEC. But where the results you have brought show that the man who won the election is the one that was declared by INEC, and you are saying the court should make a contrary declaration, whom are you trying to fool? We asked the few polling agents called by His Excellency former Governor Peter Obi. We asked them, you were the polling agent in this particular polling unit. Yes, they confirmed they were. And the election, you conducted the election freely and fairly. They said, yes, we did. The result that was given to you as the polling agent is this particular result that you are holding. He said, yes. In some places, their candidates won. In some places, their candidates lost. And now, that means that election in your polling unit was free and fair. Yes, the presiding officer or the polling agent, because said, yes, the election was free and fair. Then what are we challenging? If the result you have brought, so the only thing you are saying is that that particular result that you know is authentic, that you know is genuine, that you know is valid, You are now saying that because it was not transmitted electronically, then they should nullify that result. Who does that? It's just like saying that, okay, your child brought a result, his WAEC result, which he got from WAEC. He showed it to you. He now said that because that result was not sent to you by WAEC itself, it was your son that went and collected it, then the court should nullify that result. Does that make sense? That's right. Now, because for the fact that, okay, they had a bad case and they came to court agitating this, and more so with respect to the issue of the double nomination, it was the same PDP which was involved in the Alhaji Atiku Abubakar, His Excellency Alhaji Atiku Abubakar's petition as a second petitioner. It was the same PDP that brought this matter to the Federal High Court. The matter went to the Court of Appeal and eventually ended at the Supreme Court. Few months before the election petitions began, and the Supreme Court ruled that there was no case of double nomination, that there couldn't have been a case of double nomination because His Excellency Alhaji Kashim Shettima had actually withdrawn from the senatorial race before contesting the vice presidential election. Aside from even that, when you look at the various dates that they are talking about, there is no evidence that this man was doubly nominated. So if there was no double nomination and it had been decided by the Supreme Court, and a lawyer still had the effrontery to go back to the same Supreme Court and say, now, contradict yourself, such a lawyer ought to be heavily penalized. Right. And that is the essence of awarding costs when it comes to such cases. The lawyer should not be jailed. There's no provision for that in the law, but he must be penalized by awarding every cost against him.
That's okay. We'll have to leave this conversation here now. So many issues to look at, but time is not our friend at this point. We must thank you, Senior Advocate of Nigeria.
Can we apply for extension of time?
Unfortunately, you cannot.
Your court has ruled against me.
Yes, we have ruled against you.
And you are the Supreme Court in this case.
Senior Advocate of Nigeria, Kunle Adegoke, joined us from Paris. Thank you for your time on the program.
Thank you very much. I really appreciate you.
You're welcome.